Hi, I'm Arizona estate planning attorney Richard Keyt, and I create wills, trusts, and estate plans to protect our clients' most valuable assets, their loved ones. Now, I've had a lot of people come in and bring in their wills that were previously done before they came to see me, and I see a lot of mistakes over and over, and I'd like to explain the 11 most common mistakes that people put in their will. Now remember, the purpose of a will, it's to say who gets your assets if you die, and also it designates the person called the personal representative who's be in charge of your probate if a probate's necessary. And then if you have minor children under age 18 and you're Arizona residents, the will also designates the conservator or the person who's going to manage the assets of your minor children, and it designates the guardian, and that's the person who's going to be responsible for raising your minor children. Now let's talk about the 11 mistakes that I see in wills that you should not make. Item number one is leaving assets to a minor child. The problem with leaving assets to a minor child is that means that child is going to have control of those assets when the child reaches 18, and the child is also not going to have asset protected assets. So if you leave assets to a minor child and you don't designate a conservator in your will, then who's going to be responsible for managing those assets that are inherited by the 6-year-old or the 8-year-old? So what you really want to do is leave assets to your minor children in a trust that provides for the person who's going to manage those assets while the child is the minor. And then you can even say at what age can the child take over and be a trustee and have control of their inherited assets. Now, another mistake I see people make is they'll just have a will but no trust, and it says in the will that if they die, they're going to leave a significant amount of assets to children or other people, and these people may or may not be minors. But the problem is, even if you leave significant assets to an adult person, you're giving it to them with no asset protection. So there's two ways you can leave assets. One is outright with no asset protection. The other way you can leave assets is inside an irrevocable beneficiary controlled asset protected trust. And the difference is huge because if you leave assets outright to somebody, the creditor can get it. I had a man call me recently. He said his mother left him $275,000. The personal representative and the probate put that in his bank account, and the man had his bank account had been garnished from a previous lawsuit. So that $275,000 immediately went to the creditor, and the man got nothing. Now, what the mother should have done was she should have created a trust and left the $275,000 in the trust. And that way, the creditor would not have gotten it because legally the asset doesn't belong to the child, or in this case, the debtor. The asset belongs to the trust, and so it's asset protected from the inheritors, creditors, ex-spouses in a divorce or bankruptcy if the person files for divorce. So two ways to leave assets to people that have significant value: outright with no asset protection, or inside an irrevocable asset protected trust that gives them asset protection for life. Mistake number three is people put into their will their organ donation desires. That's not enforceable under Arizona law. If you want to make an organ donation, you have to do it a certain way. Several ways you can make an organ donation, but the most common way is to do it on a driver's license, a state ID, or a living will, and you indicate on those documents that you want to make an organ donation. Mistake number four is naming in your will who you want to inherit your IRA, your 401k, or your retirement plan assets. That's not the way you make gifts of those assets. The way you make gifts is by signing and delivering to the custodian or the appropriate person a beneficiary designation. And that designation says who inherits the assets in the IRA, the Roth, 401k, or whatever your retirement plan. You designate on your beneficiary designation who the primary beneficiary or beneficiaries are and who the contingent beneficiary or beneficiaries are. Do that on your beneficiary designation, not in your will. Mistake number five is to put in your will that if you're in a terminal condition being kept alive by a machine and you're brain dead, you want the doctors to pull the plug. That's not where you make that instruction to your doctors. You need a separate document called a living will. Mistake number six is to put into your will the people or the person you want to make medical decisions for you if you're unable. What you should do is have a separate document called the healthcare power of attorney, where it names one or more people in order as who would make decisions for you with doctors and hospitals if you're unable to do so. So don't do it in your will, do it in your healthcare power of attorney. Mistake number 7 is designating somebody in your will who you want to authorize to act as your agent and deal with your financial affairs if you're incapacitated. So that's a decision that you can make, but you indicate who you want to be your financial agent by having or by signing a financial power of attorney. That financial power of attorney designates one or more people that you give the power to deal with your financial affairs if you're mentally incapacitated. So if you're in a coma, the person you've named number 1 on your list can write checks, pay your mortgage, pay your car payments, any other expenses that you have, and deal with your financial affairs. Mistake number 8 is to put do not resuscitate instructions inside your will. Arizona has very specific requirements for a DNR, and one of the requirements is it has to be on orange paper and it has to be on letter-sized paper or wallet-sized paper. You can get the form from the Arizona Department of Health Services, and but make sure it's on orange paper or it won't be legally enforced. Mistake number 9 is designated in your will how you want assets owned by your LLC or corporation to be distributed to your loved ones after you die. For example, if you own an LLC that owns a rental property, you can't say in your will that if you die, you want that property to go to your son, because you don't own the property. Therefore, you can't dispose of it in your will. You own the LLC. So if you want that real estate to go to your son or anybody, you need to say in your will who inherits that LLC if you die. Is it one person or more than one person? And that's the way you make gifts of assets that are owned inside an LLC or corporation. You give ownership of the entity to the designated person or people in your will. Mistake number 10 is designating in your will who you want to be the beneficiary of your life insurance. Your life insurance company is not going to pay any attention to that. If you want to designate beneficiaries to receive your life insurance proceeds, you do that by filling out the life insurance company's designated beneficiary form. You sign it, you give it to the life insurance company. Now it has that on file. So if you die, somebody, namely usually the beneficiary, is going to have to give a proof of death, a death certificate to the life insurance company. And then once they see that you're deceased, they're going to pay that money to the person or people that you've named in your beneficiary designation. Mistake number 11 is only for those people who have minor children. You need to designate in your will who you want to be the conservator or the person in charge of a minor child's assets if you die. And you also need to designate a guardian. That's the person that you want to raise your minor children. Otherwise, it's not going to be, your wishes or may not be enforceable after your death. The bottom line is this: we're estate planning attorneys. If you hire us to do your will and trust and estate plan, you're not going to have any of those mistakes in your document. We're going to make sure everything's done correctly and everything's done exactly the way you want so that your loved ones are protected if something happens to you. For more information, sign up for a free office phone call, a video conference to discuss wills and trusts and answer your questions about estate planning